Good morning. My name is David Baum, and I am your host for today. We will be speaking about a topic that it's very near and dear to my heart, and you'll understand in a minute. It's Leave Nothing to Chance, the documents that everyone should have, and why. Um, Parkinson's Social Network is an all-volunteer 501c3 nonprofit organization. We were founded by a group of people with a personal connection to Parkinson's disease. Our mission is to support, advocate, educate, and enrich the lives of those touched by Parkinson's disease. And we achieved this goal by offering online resources through the website, through our YouTube channel, and through virtual events such as today's. And we also have a telephone assistance line. Here is our website URL, our email, and our telephone number. I'm sure most of the people on the call probably have that, so we'll go here and handle some housekeeping points. We ask you please to remain muted at all times throughout the presentation. Please put your questions or comments in the chat. If you are unable to use the chat feature, when I break for questions, which I will do several times during the course of the presentation, please raise your hand and one of the co-hosts will be able to call my attention to the fact that we need to get your question verbally. Today's presentation is being recorded and we will put it on our YouTube channel just as soon as we can. Um, I'm not an attorney. It's necessary for me to say that because a lot of what we're going to talk about today are things that you need to do with an attorney. I've spent my entire professional career finding solutions for challenging problems. But during that, my side gig, if you will, was for 20 years, I served as a fiduciary, which meant I was a court-appointed estate administrator. I served as an attorney in fact for many people, as executor for a number of estates, as trustee for a number of trusts, and as a healthcare proxy for a number of individuals. I'm here making this presentation today because I've been there and done that and want to share my experience with you so that you're aware from your perspective of what you need to be cognizant of. We're required to say that the purpose of this presentation is to alert you to needs that you and your loved ones should be discussing amongst yourselves and with your personal attorney. This presentation should not be considered as authoritative legal advice. I want to keep the lawyers away from the front door. What we're going to talk about today is defining the quote, critical documents, end quote, talking about each document type, why the document is important, when the document takes effect, when they expire, and when certain things happen, how you prioritize creating the different documents in order to appropriately address your immediate needs. These are the critical documents: the power of attorney, a healthcare proxy, the advance directive, and wills and trusts. The power of attorney basically is a document where you are granting someone to act on your behalf. The person who grants the power of attorney is called the grantor or the principal, and you're giving authority to your agent. They are called officially attorney in fact. There is a misinformation where somebody says, I'm power of attorney for someone. That's actually incorrect. A person is not a power of attorney. A person is either an agent or an attorney in fact. Power of attorney is a document. And the important thing to remember is even though you've granted a power of attorney, you never lose the authority to act on your behalf. We're not getting into discussions that involve conservatorship. There are three types of powers of attorney. There's a limited power of attorney, a general power of attorney, and there's a healthcare power of attorney. Powers of attorney can become effective either immediately when they're executed or when some triggering event or groups of events has occurred. And when does a power of attorney end? Well, depending on whether or not it's durable, it will end on your disability. If it's if it is durable, it doesn't end on your disability or illness. Um, all powers of attorney end when you're dead. The moment you die, all power of attorneys are meaningless. A limited power of attorney is a document that is created for the purpose of giving somebody authority to perform a specific task. An example might be a power of attorney you grant on a form that the auto dealership where you just bought a new car has you sign that gives them the authority to act on your behalf in order to sign the registration forms that they're bringing to DMV to get your license plate. Another power of attorney that is a limited power of attorney might be if you grant your real estate broker the right to represent you at closing and sign closing documents on the sale or purchase of a house. Those are limited powers of attorney. Sorry, I'm tongue-tied. A general power of attorney is a very broad document. You're granting your agent essentially to act on your behalf for all kinds of matters, financial transactions, business transactions. They basically can perform anything that you could do acting on your behalf, except in most states, healthcare. Healthcare matters do not fall within the scope of a general power of attorney in most states in the United States. The lawyers got the legislatures to separate those out and create a separate document or group of documents. General powers of attorney, because they are very broad scope, suggests that when you give somebody this authority, you make it clear to them that you want to know what they're doing on your behalf. And in fact, when somebody signs something on your behalf as an attorney, in fact, they sign your name and then they sign their name and they say attorney, in fact. So it's clear they're not forging your name. Different states have different laws regarding general powers of attorney, and this is one of the many reasons why I do not recommend you go online and get online powers of attorney forms and fill them in and use them to grant somebody a power of attorney. You need to go through a lawyer to make sure that the particular form is appropriate for your state or states, if many states are involved, and that's the safest way to do it. The worst thing that could happen would be if somewhere down the line something has been done in your name using an inappropriate power of attorney document and it gets undone as the result of a lawsuit. Healthcare powers of attorney is a term that refers to documents that have, for the most part, been replaced. They're included in this presentation because you may have heard of them. You may actually have them. Healthcare powers of attorney have been replaced by three separate documents now. Sometimes the functions are type in one long page, and they're divided into sections, where one section is an access to HIPAA-protected information. The HIPAA statute is a federal law by which all matters relating to your medical care or your health conditions become protected, and there are certain conditions under which they may or may not be disclosed. Then there's something called a medical order that your physician signs that explicitly states decisions regarding your care, and you co-sign it. And then there is the appointment of an individual to act in your behalf for matters related to your care. We'll address these in greater detail in the healthcare document section of this presentation. When is a power of attorney effective? Powers of attorney can either be effective immediately when you sign them, and the document itself has to indicate that it is becoming effective when executed. Otherwise, powers of attorney may not be effective unless there is a triggering event, some specific circumstance, or your physical inability to act. And typically, when physical ability to act is a triggering event, it requires some certification of one, or in some states, two physicians not related to you by blood or marriage, who have to certify that the medical state mentioned in the limited power, or in the power of attorney document triggering section, has been met, and therefore the attorney in fact is authorized to act on your behalf. And when does the power of attorney authority end? There are two types of powers of attorney. There is non-durable and durable. A power of attorney in most states, if it's durable, has to state in the title, and there has to be text in the document that says this is a durable power of attorney and survives your incapacity or inability to act. These, even if they're durable, expire on your death. No power of attorney of any form survives your death. That's when you're getting into estate documents. Before we go into this section, I would ask if there are any questions. Angela, has anything been posted?
No, David, no questions in the chat.
Okay. A healthcare proxy. There are multiple types of healthcare documents. The HIPAA access approval, the medical orders for life-saving treatment, and the healthcare proxy appointment. They can either be effective immediately on execution or when some triggering event occurs, and depending on the documents, the authority may end on your disability. All healthcare documents end on your death, with one exception, and I'll talk about that in a minute. The federal HIPAA law created a class of information, and it's rather lengthy, but basically think of it as anything having to do with your health, what medical conditions that you have, what treatments you have had, are contemplating to have, or actually having at a point in time, what drugs you have ever been prescribed, what drugs you're being prescribed, and what drugs you may be prescribed in the future based upon something happening in the future. In order to have access to any of that information, you either have to be yourself, or you have to have appointed an authority to access HIPAA information to somebody else. It's important to note that a HIPAA access approval document has a limited lifetime. They expire every year. You could specify a longer period of time, but varying organizations, hospitals, and medical practices adhere to a one-year expiration. That ties into, but is not necessarily driven by, the fact that many prescriptions expire in a year and have to be renewed every calendar year. In order to be sure that someone in your family or someone outside of your family who you want to know what is going on, because you may be having surgery and you want them to know that your surgery went well, or if there are any complications, you have to name them in a HIPAA access document. For example, if a doctor's office calls with results of a test, if you haven't signed a HIPAA access document allowing your spouse to be given those results, they are prohibited by federal law from providing that information. You should talk to your doctors, and a hospital to make sure that any HIPAA access approval document that you have signed in the past is still valid. Most hospitals, if you're going in for treatment, surgery, or for any other purpose testing, will provide you with an updated HIPAA access approval document to sign to make sure that test results, for example, can be shared afterwards. And they are required by law to keep them for a certain number of years. I don't remember all of the HIPAA access grants that you've made. A medical order for life-saving treatment. You may have heard the acronym MOLST, MOLST. That's what a medical order for life-saving treatment is. Some states have their own name for it. One state calls them POLST, POLST. Don't understand why, but any document that addresses life-saving treatment instructions that you have given, that your physician has approved, and that have been entered into your medical records are called MOLSTs. A MOLST document is generally prepared by you and your physician together in some appointment that you make for that purpose. Some physicians will let you fill them out, send them to them, and they'll sign them and send them back. I don't recommend that because a MOLST standard form will ask you all kinds of questions, and we'll get into that. And these are questions that should be interactively addressed between you and your physician. They shouldn't be done in absentia and then sent by email for your doctor to sign. Typical things that a MOLST document will address is whether or not you want to be resuscitated. You may have heard the acronym DNR. That means do not resuscitate. Even within a DNR order, there are some times when the doctor's orders may say that resuscitation may be permitted, not to bring you back from death, but because they had to stop your heart, for example, as part of a surgery, and they have to resuscitate you to bring you back to life at the end of the surgery. That's why a DNR order should be as specific as is possible. There is also a DNI order, which stands for do not intubate. And this is also something that has to be very specific. If you're having certain types of surgery, it may be necessary to intubate you for purposes of giving you anesthesia. The DNI order that you may choose to give typically doesn't include that and typically specifically excludes it. What DNI orders are normally given for is if you stop breathing to prevent somebody from intubating you and ultimately putting you on a ventilator and leaving you on a ventilator for as long as may occur. Some people have orders where it's okay to put you on a ventilator, but they limit it to a specific period of time, like after a week or after 30 days, or when there is no, when a number of doctors state that there's no medical likelihood of your recovering from your condition. Then there is also the issue of end-of-life treatment that you want. Examples would be, do you want to receive nutrition, which may be administered intravenously? Do you want pain management? Some people only want pain management. Some people want pain management and hydration, and some people only want hydration. These, again, are end-of-life treatments that are specifically addressed in a MOLST document. And again, these are perfect examples of why you should be interactively discussing the decisions that you want to make with your doctor so that the order is signed by both of you. Then that document should be filed with the hospitals that normally treat you and should be taken by a member of your family if you're not able to do it yourself and present it to a hospital if you're admitted through an emergency department because you've been taken somewhere in an ambulance or you've driven to the hospital. The healthcare proxy appointment is a document by which you empower someone to make medical decisions on your behalf. The healthcare proxy appointment is also a document that needs to be customized where you decide what decisions an individual may make on your behalf. In most cases, a healthcare proxy does not get the authority to override decisions you've put in your MOLST document. However, your healthcare proxy appointment document may include specific language if it's allowed in your state that grants the person to whom you've made your healthcare proxy to override provisions of your MOLST document. If that language is going to be included, it is recommended by some attorneys that you make sure your doctor has co-signed that proxy appointment so that your doctor is aware that your proxy has authority to override the MOLST document. Your healthcare proxy should always have an original proxy document, and you should only sign one healthcare proxy document. You may give copies to hospitals and doctors' offices, but the person or persons you grant should have originally signed documents. And they should take them with them when you're admitted to the hospital. This is a logical point to ask whether there are any questions.
I don't see any in the chat.
I actually have one, David.
Okay.
Oh,
I have a question about the HIPAA. So the doctor's offices provide what their HIPAA release or whatever.
Right.
Can you write your own and then provide that to all your doctors?
Legally, you can. Administratively, medical practices typically do not accept it if it's not on their form.
Oh,
You can push the issue because any legally constructed HIPAA release document should be accepted. In fact, the Department of Health and Human Services has a standard form that covers all of the bases. It's often most easy to use the one that the doctor's office gives you or the hospital gives you because they're used to it. And if there are any questions, you don't have to answer them because they're already predefined.
the reason why I ask is if in case someone just it was an oversight at the doctor's office for them to provide one, but then all of a sudden you're in a situation where you need to have access to those records or the results in order to make a determination.
They can't refuse a legally constructed one, but they typically won't accept it if you hand it to them at the time that they have handed you their form.
Oh, gotcha. Okay, thank you.
Uh-huh. Okay, advance directive. The advance directive, which some of you may have, is a term that referred to the previous method of granting the information and in providing the instructions that are in your MOLST document today. The MOLST document is much better than an advanced directive in a sense that it constitutes a medical order on your health record in the hospital. Advanced directives that weren't issued as MOLST documents can be subject to arguing and questioning, but a hospital is not going to argue necessarily a MOLST order because your physician has already signed it. And they're bound to follow physician and patient signed orders. If your state doesn't have a prescribed statute or form for most documents, then an advance directive that is prepared by an attorney who is knowledgeable in this area, and it's a very specialized area, should be prepared, should be filed with your doctor's offices, and should be filed with the hospital, and a copy should be in the possession of your healthcare proxy. This is a logical stopping point. Did anything else show up?
No.
Okay. Wills and trusts. Wills and trusts are perhaps most often thought about related to end-of-life issues. Wills and trusts are documents that are known as part of the estate planning documents group. They are critical documents, and the reason that they're critical is that the last thing you want is to die without having a will, because that really complicates the process of your estate being probated. I had a friend who died before his will was finished. I had to go to court with the consent of his mother and be appointed as the court-appointed administrator of his estate. Because he died without a will, it added almost 2 years to the process of settling his estate. Do not die without a will. Now, people have heard people that talk about wills versus trusts. There's a fundamental difference. A will is a document that only takes effect when you die. It is the document by which your decisions as to the distribution of your assets are directed to an individual or individuals you appoint as executor or co-executors. Trusts, on the other hand, a trust is a document by which you can, while you are living, establish rules and grant authorities for the distribution and management of your assets while you're living. And when you die, the trust continues, but certain rules change. Estate planning is really beyond the scope of this presentation, but I will give you a few pieces of information. There are 2 types of trusts. There is the revocable living trust, which is a trust which you grant while you're alive, and it gives your trustee or trustees authority to manage all of the assets that you have placed in your trusts. The kinds of assets that you can place in your trusts are stocks, bonds, bank accounts, jewelry, fine art. It's not recommended that you put your car in a trust or your house in a trust if the beneficiary of your trust is your spouse. If the beneficiary of your trust are your children or third parties, then many lawyers do recommend that you put your car and your house in the trust. When you die, a revocable living trust becomes an irrevocable trust. While you're alive, a revocable trust that generates income, the income is handled on your personal tax return. The tax ID number of your revocable living trust is your Social Security number. When you die, whoever is trustee, when the trust becomes irrevocable, has to apply for a tax ID number because they can no longer use your Social Security number. And the income that is generated by the assets of your trust has to be reported to the IRS annually on a trust tax return. These things in estate planning get changed quite frequently, the laws, that is. And therefore, it's important that you consult an attorney who is well-versed in estate planning, and if you have a trust and it has levels of complication in terms of tax implications, you may also have to consult a tax attorney. Again, I strongly recommend against going online and getting standard form documents unless you plan to give them to an attorney to review after you've completed them and executing them. I would point out that there is an interesting situation that applies both to your people to whom you grant a power of attorney, to whom you may appoint your healthcare proxy, to whom you may make your executor, and to whom you may make a trustee. Some people use the term co-executor, co-trustee, co-healthcare proxy. If you're going to use that term because you're granting authority to more than one person, be sure that the document indicates whether both people have to be in agreement or either of them may act independently. I strongly recommend, unless the circumstances are very unusual, that you be sure your attorney makes the document include the authority of them to act independently. Otherwise, you will unnecessarily complicate the situation, such as the fact that both of your healthcare proxies would have to be in the hospital at the same time to talk to your doctors, okay? Or both of your trustees have to be in the same place to sign the document, or they have to sign the documents independently and have them notarized. It's quite complicated if you forget when you are granting authority to act on your behalf, whether it's a power of attorney, a healthcare proxy, or a trusteeship, that you define whether or not multiple people have to agree or they can act independently. Now, suppose you don't have one or more of the critical documents and something happens in your life. Which documents are most important to have? And there are all kinds of scenarios that would change the order of importance of having a particular document. And I'm going to give you a couple of examples. I have to point out that these are examples to stimulate thought. We'll talk a little bit about variations on these example scenarios, but these are not absolute. Just the fact that the tiniest little thing in your specific circumstance can change the order of priority. And you should consult with your doctors and your lawyers and your family if there is any question about what is most priority. Here's an example that is typically one of the most common. You're going to go into the hospital for some treatment or surgery, okay? The most important document when you go in the hospital is a current MOLST order. There are very few circumstances where having a MOLST order, a MOLST document, is not the most important priority when you go in. But immediately after it is your healthcare proxy document. You want somebody to be able to make decisions within the confines of what the MOLST document says while you're in the hospital. God forbid you go in, you have anesthesia for a test, like a sedated MRI, or you have to have anesthesia for surgery, and something goes wrong and you're not coming out of anesthesia fast enough, and the doctors need to make a decision. They need to know whether or not they have authority to intubate because they're worried about having to put you in a medically induced coma. Well, if you don't have a MOLST document or you don't have a healthcare proxy, their hands are tied. The HIPAA access document is next in priority only because most hospitals will grant your healthcare proxy access to your HIPAA information. A well-constructed MOLST document or healthcare proxy document will include the provisions of HIPAA access. It'll have language that says that they are granted to access to all HIPAA controlled information about you. A durable general power of attorney is a good thing to have if you don't have such a document before you go in case you're going to be confined in the hospital for a while and there's some business transaction or bills to pay, something that would require your signature that for reasons, say you have a broken hand or your hand that you write with or your arm that has the hand that you write with has been immobilized. Say that you are in a medically induced coma. Somebody needs to do the things that you would do but for the fact that you can't do them for medical reasons. So having a durable general power of attorney is important. If you're going into the hospital for surgery and your doctors have given you an indication that there's a high probability you may not survive the surgery, then make sure you don't schedule it until you have a will or a trust established. At least a will. Wills and estate planning documents are not, quote, super critical, end quote, in most cases where you're going in for a treatment or for surgery. But with everything that can happen nowadays, all critical documents you should have them all done anyway. But the order of criticality is affected by the circumstances. Now, I'll stop for a question in case somebody has a question about this or a similar scenario.
No questions in the chat, David, but I didn't know if anybody wanted to raise their hand or um no, I guess not.
Okay. Okay, here's another one. It's kind of related. Whatever medical condition you have, whether it be Parkinson's disease or something else, has impaired your mobility, has impaired your ability to sign documents with a recognizable signature, the durable general power of attorney is critical. And the reason that it's critical is when you signed the signature cards in your bank, or you signed your mortgage, or you signed a deed for your home, or you signed the title for your car, or something else that you signed before your medical condition caused a deterioration in your handwriting, if you have to sign it and your signature is unrecognizable by the bank, the clerk of the court, or any organization who has to recognize your signature, your document may not be accepted. This is particularly important for people with Parkinson's disease who develop micrographia as the disease progresses. You have two choices. You either can contact the banks, the mortgage holders, or whatever, and ask them whether they want you to sign, whether they'll let you sign an updated signature, which in most cases involves you going with somebody who will also attest to your identity and you have necessary proof of identification, and they'll take a new sample of your signature. Or the simplest thing to do is make sure you have a durable general power of attorney so you can direct somebody to sign something for you. You can check with your attorneys whether they can think of any documents that cannot be executed because of some statute by somebody with your durable general power of attorney. But in most cases that I've come across in my 20 plus years of being the person that has that authority to act as an agent, I haven't been refused the ability to sign something. The sole exception that I've run across is that certain banks will not recognize a power of attorney, even if it's been drafted by a lawyer, even if it totally conforms with the laws of the state, but it's not on a bank form. So when you generate a durable general power of attorney, when you grant one, check with your banks. And if they require it to be on a bank form, take the bank form, attach the lawyer drafted form to it, and execute the bank form. Particularly if you're in California, because banks in California predated the law and they think they're still the law. And banks like Wells Fargo and Bank of America can be extraordinarily difficult to deal with. It took me 2 months to get the authority to sign something. And even though I was the trustee, and even though I had power of attorney, the grantor was in no condition to sign something, and they were arguing with my right to sign it. I finally had to threaten to go to court. Another document to have in this case is the HIPAA approval document, so that you have already signed it and it's recognizable. The signature is recognizable by who you're filing it with, your doctor's office or the hospital. So when someone comes to get something and they have to sign the record request form, okay, their authority has already been filed with the hospital. Same with the healthcare proxy. Having the most documents signed is not as critical, because even though your handwriting may have changed, if you have a durable general power of attorney and a healthcare proxy and your doctor, many of them will let somebody with your power of attorney and your healthcare proxy, if they're the same person, sign a MOLST document. It's different in different states. Some states require MOLST documents be signed by the grantor only. That's why I personally always consider the MOLST document to be the highest priority of the critical documents before you need it. Don't get to a scenario where you have to prioritize them. Get them all done. And obviously, estate planning documents. Are there any questions that we haven't covered?
I have a question.
Okay.
Uh, can the person with power of attorney override donations that have been in the will?
In a will?
Yes.
No, because a power of attorney has no authority after the will. And
Okay.
somebody with a power of attorney, unless the power of attorney includes the privilege of modification of a will, which most lawyers will not do, the attorney, in fact, has no authority to change a will or to change a trust,
Okay. Thank you.
either during the lifetime of the grantor or after.
Thank you.
No questions in the chat, David. I just want to let you know.
Okay, then I will stop sharing. And if there are no questions, I will stop the recording.